Good morning. It is 10 a.m. on Tuesday, July the 8th, and I'd like to call to order the board meeting for the Tennessee Board of Funeral Directors and Embalmers. As we begin the meeting, I'd like to bring your attention that there's a sign-in sheet on the table by the door, and for anyone that would like to make comments about an agenda item, please indicate so by your name as you sign in, and public comments will be accepted near the end of our board meeting. Ms. Bohannon, would you call the roll, please?
Don Haynes. Here. Chris Lee.
Here.
Randy Nash. Here. Wendell Naylor. Here. Scotty Porsche. Pam Stevens. Here. Tim Willer. Here. Mr. President, we have a quorum.
Thank you, Ms. Bohannon. First thing we need to do is to adopt today's agenda. I'll accept a motion and a second.
I make a motion we accept the agenda.
Second.
Have a motion by Mr. Wheeler, a second by Ms. Stevens. All in favor, respond by saying aye. Aye. Any opposed? Motion carries. Second thing on our agenda is the approval of the meeting minutes from June 10th, 2025. Everyone should have received those. I'll open the floor for any discussion. If not, I'll accept a motion.
I make a motion we accept the meeting minutes from our June meeting.
Second.
Have a motion by Mr. Wheeler and a second by Mr. Haynes. All in favor, respond by saying aye. Aye. Any opposed? Motion carried. Now have our legal report. Mr. Bryant, we'll turn it over to you, sir.
Good morning, board members. First complaint is complaint number 2025-004551. A complaint was submitted by respondent's previous employer stating that respondent had stolen money from him while employed. In discussion with legal, the complainant indicated that respondent had taken checks linked to the funeral home's bank account and had written them for personal use. Legal obtained a copy of the judgment documents from the criminal court. On April 17, 2025, respondent pled guilty to a charge of forgery for $1,000 or less, a Class E felony, and guilty to a charge for forgery for more than $10,000 but less than $60,000, a Class C felony. Pursuant to 10 Comp RN Regs 0660-01-.03, respondent is required to report in writing to the board within 10 days the conviction of any felony. Respondent did not inform the board office of either of these convictions. So based on the above, we'd recommend revocation of respondent's embalmer's license, authorized via consent order, and a formal hearing if necessary. And just for the board's information on that one, with this respondent, they have an embalmer's license only, no funeral director's license.
That was the only question I had. Is there any discussion?
Has they paid back to the funeral home what they wrote checks for?
I do know part of the court's order was restitution in the form of that check. I do not know if that's been paid at this time. Again, I think the arraignment hearing was April 17th of this year. I'm not sure what. When I made the records request from the court, they sent over the judgment documents that they have, but I don't know if a formal order detailing the timeline, all of that. So, short answer to your question is I'm not entirely sure.
Okay. The other question I have for the your recommending revocation of the respondent's embalmer's license, is there a recommendation for how long?
So with, I guess the distinction between a revocation and suspension is that suspension would be a suspended license for a period of time that upon the ending of that term, whether it be 6 months, a year, 2 years, whatever, then the license would automatically reinstate. Here with a revocation, it would be permanently. That would never reinstate. The respondent could at any time come back before the board, make an application to be licensed again, but obviously this would be on the record and they would probably have some hard questions to answer about all of that. So for a revocation, there is no time period in mind. It is a
More permanent.
Exactly.
Okay. Thank you.
I make a motion to approve recommendation.
Second.
Have a motion by Mr. Nash, a second by Mr. Naylor for council's recommendation of revocation of respondent's embalmer's license and authorized via consent order and formal hearing if necessary. All in favor, please respond by saying aye. Aye. Any opposed? Motion carried. Number 2.
Next complaint is complaint number 2025-027571. This case was administratively opened following a routine inspection conducted on April 28, 2025. During the course of this routine inspection, the inspector observed the following. An employee of respondent establishment permitted their funeral director's license to expire on January 31st, 2025, and did not meet the requirements to reinstate the license until February 28th, 2025. During the unlicensed period, the employee acted in the capacity of a funeral director by making cremation arrangements and being listed as a Tennessee licensed funeral director on the death certificate for 2 decedents. Respondent replied through counsel, stating that he acknowledged the license had expired. Respondent stated that due to an address change, the employee did not receive mail for a period of time and as a result did not receive notice of the license expiration. Respondent stated that the expiration was a mistake and that they apologized. So based on the above, we'd recommend a $500 civil penalty authorized via consent order and a formal hearing if necessary.
Any discussion or questions? If not, I'll entertain a motion.
I make a motion we accept council's recommendation.
Have a motion by Mr. Wheeler, a second by Mr. Haynes to accept council's recommendation, $500 civil penalty authorized via consent order and formal hearing if necessary. All in favor, please respond by saying aye. Aye. Any opposed? Motion carries. Number 3.
Number 3 is complaint number 2025-027581. This case was administratively opened following a routine inspection conducted on April 28, 2025. During the course of this routine inspection, the inspector observed the following. The respondent in this case is the employee from the preceding complaint. And just as a refresher, the respondent permitted their license to expire on January 31st, 2025, renewed that license on February 28th, 2025, and in that interim with this location, acted in the capacity of a funeral director by making cremation arrangements and being listed as a licensed funeral director on the death certificate for 2 decedents. And respondent reiterated their response from the previous complaint. And based on the above, would recommend a $250 civil penalty authorized via consent order and formal hearing if necessary.
Any questions? If not, Chair, I'm sorry.
Let's see. What is the difference between the two? I'm a little confused. The first, the one ending 7571 and the one ending 7581.
Yes. So number 2, ending 7571, is the funeral establishment for the violation, essentially, of having an employee conduct license activity without a valid or expired license. And 3 is the individual themselves for their expiration of the license and then continuing to conduct license activity.
Okay, thank you.
Any more questions or comments?
Motion to approve.
Second.
Have a motion by Mr. Nash, a second by Ms. Stevens, to accept council's recommendation of a $250 civil penalty authorized via consent order and formal hearing if necessary. All in favor, please respond by saying aye. Aye. Any opposed? Motion carries. Number 4.
Next complaint is complaint number 2025-027591. This case was administratively open following a routine inspection conducted on April 28, 2025. During the course of this routine inspection, the inspector observed the following. An employee with a respondent establishment permitted their funeral director's license to expire on January 31st, 2025, and did not meet the requirements for reinstatement until February 28th, 2025. During the unlicensed period, the employee acted as a Tennessee licensed funeral director by making funeral arrangements or being listed as a Tennessee licensed funeral director on the certificate of death for 4 decedents. Respondent acknowledged that the employee's license had temporarily lapsed and stated this was a mistake that the establishment and employee apologized for. Additionally, the reason for embalming was not listed on several statements of funeral goods and services when an embalming fee was charged as required by FTC rule. Respondent stated this was a clerical error made by staff. Respondent stated that while it may not have been included on the statement of funeral goods and services as part of the arrangement process, all families understood the reason why embalming was charged for the decedent. Respondent stated they will retrain their staff on correct data entry to avoid these errors in the future. Based on the above, we'd recommend a $750 civil penalty authorized via consent order and formal hearing if necessary.
Any questions or comments?
Yeah, I have it. So for B, if I understand correctly, The statement of goods and services did not reflect the cost of embalming. However, the families were charged for it.
My understanding is that it did reflect the cost, but didn't state the reason why.
Okay.
So everything looked good, minus including the reason for embalming on those statement of funeral goods and services.
Okay, thank you.
Any other comments, questions? If not, the chair will entertain a motion.
Motion to accept council's recommendation.
Second.
$750 fine.
Have a motion by Mr. Haynes, a second by Mr. Nash, to accept council's recommendation, $750 civil penalty, authorized via consent order, and formal hearing if necessary. All in favor, please respond by saying aye. Aye. Any opposed? Motion carries. Number 5.
Number 5 is complaint number 2025-027601. This case was administratively opened following a routine inspection conducted on April 28, 2025. During the course of this routine inspection, the inspector observed the following. The respondent in this matter is the employee from the preceding complaint. And again, just as a refresher, they permitted their funeral director's license to expire on January 31st, 2025, was reinstated on February 28th, 2025, and during that unlicensed period, they acted as a Tennessee licensed funeral director by making funeral arrangements or being listed as a funeral director on the certificate of death for 4 decedents. And again, respondent acknowledged that their license had expired during the identified period due to an address change. During that time, they did not receive mail, so did not receive the notice of the license expiration. So based on the above, we'd recommend a $250 civil penalty authorized via consent order and formal hearing if necessary.
Any questions or discussions or comments? If not, the chair will entertain a motion.
Motion to accept.
Do we have a second? Second. Have a motion by Mr. Nash, a second by Mr. Naylor, to accept council's recommendation, $250 civil penalty, authorized via consent order and formal hearing if necessary. All in favor, please respond by saying aye. Aye. Any opposed? Motion carries. Number 6.
Next complaint is complaint number 2025-027611. This case was administratively opened following a routine inspection conducted on April 28th, 2025. During the course of this routine inspection, the inspector observed the following. The individual in the preceding complaint is the manager of this respondent establishment. So the first finding was that respondent's manager, that individual who permitted their license to expire, during the time of the invalid license, that individual served in the capacity as manager for respondent establishment, and the respondent reiterated their response from the previous complaints. Additionally, the inspector also found that the reason for embalming was not listed on numerous statement of funeral goods and services selected when an embalming fee was charged as required by the FTC. And again, respondent reiterated their response from the previous complaint, stating that it was a clerical error and they are in the process of retraining staff for correct data entry. So based on the above, we'd recommend a $750 civil penalty authorized via consent order and formal hearing if necessary.
Any questions or comments? If not, the chair will entertain a motion.
I make a motion we accept council's recommendation.
Second.
Have a motion by Mr. Wheeler, a second by Mr. Naylor, to accept council's recommendation, $750 civil penalty, authorized via consent order and formal hearing if necessary. All those in favor respond by saying aye. Aye. Any opposed? Motion carries. Number 7.
Number 7 is complaint number 2025-27851. This case was administratively opened following a routine inspection conducted on April 15th, 2025. During the course of this routine inspection, the inspector observed the following. Respondent's manager permitted their funeral director's license to expire on February 28th, 2025, and did not meet the requirements for reinstatement until March 10th, 2025. During the time of the invalid license, the individual continued to operate as manager of respondent establishment. Respondent stated that during the unlicensed period, the respondent establishment did not conduct any business, and the manager stated that even if they had, they would not have operated as a funeral director. Based on the above, we'd recommend a $250 civil penalty, authorized via consent order and formal hearing if necessary.
Any questions or comments? If not, the chair will entertain a motion.
Motion to accept.
Second.
Have a motion by Mr. Nash, a second by Mr. Haynes to accept council's recommendation, $250 civil penalty, authorized via consent order, and formal hearing if necessary. All those in favor respond by saying aye. Aye. Any opposed? Motion carries. Number 8.
Number 8 is complaint number 2025-027731. This case was administratively opened following a routine inspection conducted on April 15th, 2025. During the course of this routine inspection, the inspector observed the following. The respondent, the individual in this case, is the manager from the preceding complaint. And just as a reminder, the respondent permitted their license to expire on February 28th, 2025, did not meet the requirements for reinstatement until March 10th, 2025, and during the time of the invalid license, respondent continued to operate as manager of the funeral establishment. So based on the above, we'd recommend a $250 civil penalty authorized via consent order and formal hearing if necessary.
I have a question,
Yes,
please.
ma'am.
Do we know how many cases were conducted during that time?
From my recollection of this one, it truly seemed that no cases were conducted during that time period, which is always a good thing, that unlicensed activity isn't occurring. It seems like a 9-day stretch, I think, 10 days. So I could see, I guess, a smaller location that doesn't regularly conduct business. But in the rules and statutes is that essentially at all times, the person who's implemented as manager has to have that valid license. So even if you're not doing business, which is good, we're not breaking other rules on the way, that person appointed as manager just has to have a valid license, and for 9-10 days, they did not.
Thank you. Move for approval, legal's recommendation.
Second.
Have a motion by Ms. Stevens, a second by Mr. Wheeler to accept council's recommendation, $250 civil penalty, authorized via consent order and formal hearing if necessary. All those in favor respond by saying aye. Aye. Any opposed? Motion carries. Number 9 and 10, I guess, Mr. Bryant?
Yes, 9 and 10 go together. They involve the same individual. Number 9 is complaint number 2025-028411 regarding this individual's funeral director's license. And number 10 is complaint number 2025-033871 involving this individual's Embalmers license. So complainant stated that the funeral home with which respondent is employed handled their mother's arrangements. Complainant alleged that while he was, quote, visibly grieving and physically holding the urn containing their mother's ashes, end quote, respondent offered what he believed to be a consoling hug. Respondent stated, however, that, quote, the hug lingered uncomfortably and he then kissed me on my cheek neck area without my consent, end quote. Complainant stated that later that day, respondent sent him text messages stating that he, quote, really liked him, end quote, and suggesting further personal interaction. Complainant stated that respondent knew or should have known this to be inappropriate due to the timing and situation. Respondent replied, stating that he had met with the complainant to exchange his mother's ashes and to fill the selected urn. Respondent said during the interaction he offered a hug as a gesture of comfort, which complainant accepted. Respondent stated that, quote, at no time was this gesture prolonged or inappropriate, end quote. Respondent said additionally, in their role as minister, he offered, quote, a brief kiss on the cheek and verbally expressed my condolences for the loss of his mother. This expression was made purely out of compassion and respect with no romantic or suggestive intent, end quote. Respondent stated, as he has often done throughout his 30-year career in funeral service and ministry, that he invited complainant to reach out if he were in town, as he often extends meals or conversation to service those in times of need, and that this was a long-standing pastoral practice rooted in care and hospitality, not a personal overture. Respondent stated he followed up via text messages to ask if he had done anything that made complainant feel uncomfortable. Respondent stated that nonetheless, after conferring with the owner of the establishment, they agreed to refund the full cost of the funeral in the amount of $3,077.87. Respondent stated a few days later, complainant contacted them again, requesting an additional $5,000, claiming this, quote, would ensure he never did this to another person again, end quote. Respondent stated ultimately a cashier's check for $8,077.87 was issued to complainant, and that respondent's desire to settle was from a sincere desire to avoid unnecessary conflict for what respondent intended to be a comforting gesture. Respondent stated that in response to this, he has issued a direct and sincere apology to complainant, has provided full financial reimbursement beyond what was contractually required, and has implemented new internal policies, including obtaining express consent before offering physical gestures of comfort, such as hugs, and that he will no longer offer cheek kisses, even as a cultural or pastoral gesture to avoid any possible misunderstandings. The owner of the establishment also submitted a response, stating that they followed up with complainant once they were contacted regarding the alleged incident. The owner said that complainant described meeting with respondent on 3 separate occasions, and that respondent had hugged him during each of those encounters, and mentioned that respondent invited him to dinner should he ever return to town. The owner stated they took these matters seriously, but also provided that this was consistent with the character and professional demeanor of respondent. The owner stated respondent is an ordained minister and is known for being affectionate in a respectful and comforting way toward families experiencing grief, and that the behavior has always been rooted in compassion and pastoral care. Respondent stated that during this conversation, complainant expressed dissatisfaction with the services provided and requested reimbursement. The owner stated per their GPL, a refund will be issued if the client is not satisfied with any portion of their services, and as such agreed to refund the $3,077.87 as a professional courtesy. However, after the agreement was made, the owner stated complainant contacted the owner again and, quote, demanded $5,000, which the owner assumed was $5,000 total combined with the original refund. The owner stated they were prepared to honor this, though it exceeded the cost of the arrangements. The owner stated complainant returned a third time, requesting $5,000 in addition to the refund of $3,077.87. The owner provided that despite their growing concern regarding the legitimacy and intent of complainant's claims, both they and respondent wished to avoid further conflict and resolve the issue without further escalation. The release was signed and executed June 6, 2025 by the complainant. Legal spoke to the complainant on June 16, 2025. Due to the personal nature of the complaint, legal inquired as to what complainant's hopeful resolution is and explained the board's jurisdiction, authority, and typical nature in which disciplinary action, if any, is issued by the board, such as letter of warning, caution, instruction, civil penalty, license suspension, revocation, etc. Complainant stated they did not wish for respondent to lose their license or face civil penalty, only for something to be included on the record in respondent's file in the event such further action was to ever occur again. During this conversation, complainant did not mention to legal the release or agreed upon compensation from respondent. So based on the above, in line with my discussions with complainant on what they would like the resolution to be, we'd recommend a letter of warning.
Thank you, Mr. Bryant. I have one question. Back to paragraph 1. Did council, by chance, happen to see the text messages that indicated inappropriation? Or not appropriate activity, I'm sorry.
Yes, they were included with the complaint. It's one of those, I think, when you read it from the complainant's perspective, you can see potential inappropriate, behavior. And then when you read it with respondent's reply, you can also see that angle. I think the weakness of textual communication is that tone is often very difficult to discern. One thing I will mention too is I think we had a case, not quite like this, but probably about 2 or 3 years ago, where there was a complainant who felt that a hug from a funeral director had lingered a little too long. And I think at the end, a lot of what goes into this is the intent of the respondent. And unfortunately, we're just not in a position to know what was in the respondent's head or what was in their heart at the time when they, reached out to complain in this manner that they were uncomfortable with. So I do think intent is really difficult to ascertain. But the reason I reach out to complain is because with such a personal, I guess what they're viewing as a personal violation against them individually, this is up for you to decide, but I think that they have a little more weight than maybe the average complainant would. And they seemed pretty adamant with me. We talked about 10 minutes or so that, don't want this individual to, I just wanted on the record that if it ever happens again, then the board is aware of that.
Thank you. And I think we all know, sadly, that text messages have no emotions. You can read it or send it and interpret it many different ways. And I'm not necessarily disagreeing, but with what I've seen here, does the board think A letter of warning is kind of when you find something wrong. I'm thinking more like, I don't know if I'm looking for a letter of instruction or something like that, that if this did happen, it is in your best interest not to, does that make sense? What I'm saying?
Presently-
I've got a couple issues with this. I'm sorry, Ms. Stevens.
I have real issues with it. First of all, if they wanted it for, if the complainant wanted for the record, why are they asking for
Yeah, this is-
hostage money?
I'm no attorney, but is this not considered extortion? I mean,
It is
demanding
extortion.
money for something. I just
It is.
I don't and I don't think that we as a board, this is my personal opinion, that we are in the business of reprimanding licensees for, a gentleman, I'm assuming a gentleman, hugging someone and the other person, they didn't like it and they demanded, they offered the owner of the establishment and the funeral director, I'm guessing himself, offered to refund the amount of the contract to rectify this. Then that person demanded another $5,000. I personally have I have an issue putting anything in this licensee's file, regardless of what it is, letter of
They're
instruction.
not wanting anything done to them at the end. I mean,
Yeah,
yeah,
I
I just didn't feel,
And I think that's perfectly fair. That's why I wanted to include that information, because kind of the timeline of how this complaint came in. We got the complaint, basically kind of included those text messages and explained what happened, maybe about 2 paragraphs or so. The response came in, but it came in just a little late. Nobody's fault. I think just it was mailed, so it took a little longer to get here. So it was referred to me without a response initially, and then after a few days it came in. And then I think in that interim, if I'm remembering correctly, I still did not have a response, and I called the complainant and then had that conversation. And at this point, I have no idea about the funds or anything, and then that information came out.
And the complaint never mentioned it to you either.
Did not, either in their formal complaint that they filed or during our phone conversation.
And did I see where it says release was signed and executed June the 6th. So was that a release that was drawn up between the parties? And do you have a
That's-
copy of that?
Yes, I did receive a copy of that. It was drawn up between the parties, and if I'm remembering my timeline correctly, the complaint in order of operations, the complaint was filed first, I think very early June or late May. And then that agreement was signed and executed June 6th. And then my conversation happened with complaint about 10 days later.
So if this person filed the complaint, then demanded the money, it sounds like.
Possibly. I'm not sure if they had, because I know when the owner wrote in, they said, we kind of agreed for a refund, and then they came back, and then they came back again. I think that was working either behind the scenes while they were filing a complaint, or they filed the complaint and then had those conversations. I'm not entirely sure how that checks out.
I make a motion that we dismiss this complaint.
so it's my understanding we have a motion for closure by Mr. Nash.
Yes,
We have a
sir.
second,
Yes, sir.
and a second by Mr. Naylor.
And Mr. Nash and Mr. Naylor, just for the record, I assume that would be closure for both complaints, 9 and 10?
Yes, sir.
Yes.
We have a motion on the floor for complaint 9 and complaint 10 by Mr. Nash and second by Mr. Naylor for closure on both complaints. All in favor, please respond by saying aye.
Aye.
Any opposed? Motion carries. Number 11, Mr. Bryant.
Last complaint is complaint number 2025-031241. Complainant, the mother-in-law of the decedent, stated that her son-in-law died on April 6, 2025, and that her daughter, the purported wife of the decedent, did not learn about it until April 27th, 2025, from a third party. Complainant alleged that respondent never notified her daughter, the legal next of kin, about the decedent's passing. Complainant stated that upon receiving the death certificate denoted the decedent as married and says that the marital status of the decedent should not be in question. Again, complainant stated that her daughter was never contacted to make the arrangements or after the arrangements had been made, and that due to the information being filled out on the death certificate as married, respondent knew or should have known to reach out to the decedent's wife. Respondent replied through counsel stating that the individual who handled the decedent's care was the mother of the decedent. Respondent stated the mother engaged their services with a valid durable power of attorney for healthcare document, which specifically authorized the decedent's mother to make determination of the decedent's remains. Respondent attached a copy of the executed power of attorney document to their response. Respondent stated they have no specific knowledge as to the family dynamics of the family involved, as to when or if the family of the decedent notified the wife of the decedent, but stated that it was their understanding that the decedent and the wife had been separated at the time of decedent's illness and death. Complainant provided a rebuttal attaching a marriage certificate and the death certificate. Based upon the valid execution of a durable power of attorney document granting authority to the decedent's mother, legal recommends that the complaint be closed. And for benefit of the complainant, just to have it on the record, legal understands that the decedent and complainant's daughter may still have been legally married, but per the pertinent statute, a power of attorney supersedes the authority of a living spouse regarding the right of disposition. Therefore, legal recommends closure.
Make a recommendation to accept legal's recommendation.
Second.
Have a motion by Ms. Stevens and a second by Mr. Wheeler to accept council's recommendation of closure. All those in favor respond by saying aye. Aye. All opposed? None. Motion carries. I'd like to add just something to that. That's what a lot of folks don't understand. They'll have power of attorney for health care or monetary or whatever that ends at death. You have to have that clause in there, Mr. Bryant, if I'm correct, that it extends beyond death for final disposition. Am I correct on that?
That is correct, yes. Your typical power of attorney, just your standard out-of-the-box one, I would say, does not always include decision-making at the time of and after death. And then some kind of looking ahead will include that, and then other times you need a new one to be executed. But yes, that in the pertinent statute and kind of your order of operations, durable power of attorney that contemplates post-death decisions and at the time of death decisions supersedes a spouse.
Thank you, Ms. Bryant. I think that's just good food for thought with anybody that may be watching, and thank you very much for this legal report. Mr. Gribble, next on the agenda is the Executive Director's Report.
Thank you, Mr. President. Good morning, board members. The first thing is a report of licenses administratively approved by the Executive Director pursuant to Board authority for the period of June 7, 2025 through July 1, 2025. Have one establishment and 6 individuals. Some approved by reciprocity and reapplication. Next is the disciplinary action report. It's a report of consent orders that have been administratively accepted and approved by the Executive Director pursuant to Board authority and as reported on the May 2025 Regulatory Board Disciplinary Action Report. Have a list of the respondents or location violations and the action that was taken against them in those situations. Next is a list of the complaints for this board meeting. As of July 8, 2025, we had a total of 72 complaints open. 41 of those were with funeral directors and/or embalmers, and 31 with establishments. There are no closed establishments to report at this meeting, so, Mr. President, that concludes my report. I'll be glad to answer questions if any board member has questions.
Thank you, as always, Mr. Gribble. Any questions or comments for Mr. Gribble? Have a motion by Mr. Nash to accept the Executive Director's report. Do I have a second?
Second.
Have a second by Mr. Wheeler. All in favor, please respond by saying aye. Aye. Any opposed? Motion carries. Mr. Gribble, are there any applicants and individuals to appear before the board?
There's one establishment, Comfort Cremation Center, which the manager is to be Sean Scott Williamson, 8911 Dallas Hollett Road, Suite 105, Saudi Daisy, Tennessee, and the owner is a limited liability company, which is Comfort Cremation LLC, with a location at 3918 Tennessee Avenue, Suite 104 in Chattanooga. I think Ms. Williamson is here today and probably ready to address the board. If you don't care, just kind of tell them what you're.
Sure.
Introduce yourself. And tell
I'm
us a
Shawn
little bit
Williamson. I own 2 other funeral homes, and this is going to be a lower-end branch. service for families that can't afford full price.
Mr. Gribble, as far as on the state end, other than coming before us, I noticed this is a reinspection, so I'm assuming whatever initially was a problem has been taken care of.
Mr. Bryan and I have spoken, and as far as laws or rules, we know of no reason hindering the application.
Do I have any questions or comments or anything from Ms. Williamson from the board members?
And you are correct, there was a re-inspection and there was an issue addressed between the two inspections.
Is this in the I looked through this. Is this in the building of your existing funeral home?
It's on another floor, so it has a separate entrance and everything, but yes, it is in the same building, but it has its own suite number, own address,
Okay.
own phone number, everything's separate.
So when you take a call for comfort cremation and the family wants to identify, where would that family go for the identification?
So I have the ability to allow them to come into the upstairs of the building to identify. We also have the ability to do identity by picture, by photograph. It pops up on a screen for like 10 seconds and disappears, and just to give them peace of mind. Most families decline viewing them at all.
So this is actually in the building of the establishment itself. It's just.
Correct.
Okay.
It's a huge building.
Yeah,
We
that's
way
what I
overbuilt.
noticed.
It's like 1 million square feet, and it's basically, but it's a separate entrance. It's a whole nother level. No families will go down there on that level from Legacy.
And it's probably in your paperwork, but who do you use for your, who's your retort, and do you
I
all
own my
have
own.
that?
It's
You have
right
that?
there on property.
That's what I thought.
Mhm.
Okay, thank you.
Sure.
That is an interesting colored couch.
Yes.
Oh, isn't that beautiful? I found that, and I love it so much.
It's very colorful and
Yes, it's
cheerful.
very happy. Yes, it's very comfortable too.
What about the fur-lined chair? That was my favorite.
Well, I know David Shannon said, "Is this thing gonna hold me?" I said, "Sit down."
Thank you so much, Ms. Williamson. Any more questions? If not, I'll entertain a motion from the board.
I make a motion to accept, or to approve the establishment, excuse me.
Have a motion by Mr. Nash to accept the approval of Comfort Cremation Center. Do I have a second?
Second.
Have a second by Mr. Naylor. All in favor, please respond by saying aye. Aye. Any opposed? Motion carries.
Thank you all for your time.
Congratulations, and we
Thank
wish
you.
you the best.
Thank you so much.
Mr. Gribble, are there any more establishments or individuals?
No, sir, that's all.
Thank you, sir. Under new business, we have the 2026 board meeting dates, and that was included in your package. Are there any discussions about that, or I guess we'll need to approve that for next year? I know this building and the state and everything's on a tight schedule, and all these other boards are meeting, so I'm sure the sooner the better we do that.
I make a motion, we accept the board meeting dates for 2026.
Have a motion by Mr. Wheeler and a second by Mr. Haynes to accept the board meeting dates for 2026. That's included in the agenda today. All in favor, please respond by saying aye. Any opposed? Motion carries. Ms. Bohannon, did anyone sign up for public comment for today's meeting?
No, sir.
What about virtually? Is anyone on virtually that would like to speak?
No, sir.
Thank you, Mr. Gribble. Thank you, Ms. Bohannon. It's kind of weird, but I want to make sure. Adjourn? Nothing I missed this week? All right, the board chair will, I'm sorry. Go right
Move
ahead.
for approval for adjournment.
Have a motion by Ms. Stevens and a second by
Second.
Mr. Nash. Meeting is adjourned. Thank you all for coming, and please be safe.